This course is brought to you by Comcast NBC Universal. We would like to thank Comcast NBC Universal for their generosity in making this course possible.
Learning objectives. 1. Define the Office of Federal Contract Compliance Programs, Ofccp. 2. Explain how companies with federal contracts adhere to the OFCC regulations. 3. Identify the groups of veterans who are protected under the OFCCP. 4. Define the affirmative action plan that government contractors are required to put into place. 5. Discuss the ways contractors talk to veterans about reasonable accommodation. 6. Assess the ways contractors effectively employ an affirmative action plan.
So what is the Office of Federal Contract Compliance Programs, otherwise known as OFCCP? OFCCP is one of 4 subsidiary organizations within the Department of Labor. They were created when the departments were reorganized in 2009.
OFCCP enforces the rules and regulations that were passed by Congress. These laws and regulations contain the guidelines that OFCCP uses. Updates to those regulations are often issued as rulings. These rulings are often updated. For instance, the updates to the Vietnam-era Veterans Readjustment Act of 1974, or VEVRA, the newest update to this ruling takes into account post-9/11 veterans. As of January 2015, all companies that are government contractors are required to be in compliance. The 41 CFR Part 60-300, also known as the Veterans Rule, expands the affirmative action plan and outreach requirements, as well as formalizes some specific hiring goals for certain types of veterans.
One of the confusing aspects of employing veterans is that there's no single or standardized definition of what a veteran actually is. Let's look at the Veterans Administration's definition of a veteran. A person who served in active duty and was discharged or released under conditions other than dishonorable. But let's go ahead and dig a little deeper.
So which group of veterans does the rule apply to? The veterans that are known as protective veterans are those who are protected by the OFCCP regulations. A protective veteran is a veteran who is protected under the non-discrimination and affirmative action provision of VEVRA. For example, a veteran who may be classified as a disabled veteran, a recently separated veteran, an active duty wartime or campaign badge veteran, or an Armed Forces Service Medal veteran. In addition, there's what's known as pre-JVA veterans.
The first of 4 different categories for protected veterans is disabled veterans. The federal definition of a disabled veteran is the most important, as state definitions may not be applicable. If a veteran has a disabling condition, which is recognized by the VA, then they are a disabled veteran. One important thing to recognize about veterans who are disabled is that they also count twice when it comes to affirmative action reporting. Disabled veterans count once as a veteran and twice as a person with a disability, so you're able to count that same person in 2 different categories when it comes to compliance reporting.
Documentation for disabled veterans provided by the VA. Although you are likely to be prohibited from asking to see this documentation, in cases where the veteran is unsure of their own status in terms of disability, they can go to the Veterans Administration and ask for one of these forms and use it to determine their status. Let's go ahead and take a look at the second category, veterans who were recently separated. Recently separated veterans are those who have departed from duty within a 3-year period at the end of their active service. However, there are some exceptions, such as our Reserve and National Guard members who have served but not on federal service or were not mobilized to go overseas. So a recently separated veteran who departed the National Guard in the last 3 years would not fall under this category unless they had served overseas or been activated for federal service. The third type of protected veteran is the campaign badge veteran. With military personnel conducting campaigns around the world, these campaigns are recognized by the official issuance of medals and badges by the Department of Defense. The next category of protected veterans is the active duty wartime veteran. This category is particularly interesting because although the United States has been involved in a variety of different military activities, the last time the United States was technically at war was World War II. So when determining the preference for veterans in this category, it's important to recognize that if someone has a World War II service, they qualify, but also if they have served in a variety of war activities, which have been performed since, they also may be eligible. Now that we're well versed in the different categories of a veteran, let's look at the affirmative action plan and any other requirements for OFCCP reporting. We'll be looking at how to apply the information that we've learned in Module 1 in terms of creating, recording, reporting, auditing, and benchmarking for the affirmative action plan that government contractors are required to put into place.
The first element of the affirmative action plan we'll look at is the affirmative action policy statement. Contractors or subcontractors are required to provide an equal employment opportunity policy statement in accordance with the VEVRA affirmative action plan regulations. The policy must indicate that the top U.S. executive of the contractor must support the affirmative action plan.
The VEVRA states that every government contractor posts the Equal Employment Opportunity Policy Statement in their building. The CEO and human resources professionals must create a policy statement that consists of the following. 1. The policy statement should include the Chief Executive Officer's attitude on the subject of equal opportunity hiring, provide an audit reporting system, and assign overall responsibility for the implementation of affirmative action activities. 2. The policy should state that the contractor will recruit, hire, train, and promote persons in all job titles and ensure that all other personnel actions are administered without regard to protected veteran status. 3. The policy should state that any act or practice that goes against VEVRA or its implementation regulations is deemed unlawful. 4. It should exercise any other right protected by VEVRA. The next area that we are going to look at is reasonable accommodation. Veterans may have disabling conditions which might require special accommodations so they are able to perform their tasks at work. Because veterans are protected in the affirmative action plan, it is important to recognize if a disabled veteran is having problems performing their task. It is incumbent on the contractor to confidentially inform that employee that there is a problem with their performance. The contractor is then required to ask if the problem is related to the disability. If it is, then the contractor must confidentially inquire or ask the employee if he or she needs any special accommodations to help perform their tasks. Compliance must be reported. It's important that every contractor who works with subcontractors provide written notification of the prime contractor's company policy. They should then notify the subcontractors and request the appropriate action to keep up with compliance. It is also important the contractor documents your written notification and includes it with the affirmative action plan. If it is not recorded in the eyes of the inspector, it never occurred. In order to hire veterans, a government contracting company must be able to reach out to the veteran community. It's important to recognize that reaching out isn't enough. Companies are required to record what steps they have taken to outreach towards veterans. The definition of outreach are activities that are designed to effectively recruit protected veterans. Contractors must record these efforts and evaluate them for their effectiveness.
It is important to disseminate information concerning the affirmative action policy for a company within the organization's policy manual. If your organization is unionized or employees have a collective bargaining agreements, it is also important and required for contractors to notify union officials of the affirmative action policy and request that they cooperate with the requirements.
The next area that we are going to look at is reasonable accommodation. Veterans may have disabling conditions which might require special accommodations so they're able to perform their tasks at work. Because veterans are protected in the affirmative action plan, it's important to recognize if a disabled veteran is having problems performing their tasks. It is incumbent on the contractor to confidentially inform that employee that there's a problem with their performance. The contractor is then required to ask if the problem is related to their disability. If it is, then the contractor must confidentially inquire or ask the employee if he or she need any special accommodations to help them perform their tasks.
The next section is what applies to the audit and reporting systems. In order to effectively employ an affirmative action plan, the ruling requires contractors to design and implement their own self-auditing and recording system. These areas, which the reporting systems are required to address, measure the effectiveness of the affirmative action plan contract, indicate any need for remedial action, and determine the degree to which the affirmative action plan objectives have been attained. They also determine whether known protective veterans have had the opportunity to participate in all sponsored educational, training, recreational, and social activities. They measure the contractor's compliance with the affirmative action plan's specific obligations. The self-audit table provides what is in essence a checklist to ensure compliance with each element of the VEVRA Affirmative Action Plan, or AAP. The first column of the VEVRA AAP is simply the location of the regulation within the ruling. The second column is the requirements, which encompass the portion of regulation you are required to perform. The third column ensures that you are in compliance with the regulations. The next section of the ruling we're going to look at is data collection analysis. This is important because this information is going to be your baseline data benchmarking. It can also be used to gauge the efficacy of outreach activities and your company's affirmative action policy. A significant component of the ruling is the establishment of a benchmark for hiring. Benchmarking is a way that you can gauge your success when it comes to hiring veterans. The purpose of benchmarking is to establish a quantifiable method which will measure the opportunity for protective veterans as a whole. The goal for Ofccp's regulations is to have 8% of your contractors be veterans. The 8% is not a quota. Failure to meet the 8% is not a violation. Additionally, it is important to remember that benchmarking must be applied across the entire company, and if you are a government contractor, in each establishment within a company.
There are exceptions to every rule. In cases where a company does not want to use 8% for its benchmark, they're afforded the opportunity to develop their own tailored benchmarks. However, it is required to maintain all associated records for a period of 3 years and use 5 specific factors.
The first factor deals with the availability of veterans in the labor force. The Department of Labor requires that a contractor look at the average percentage of veterans in the civilian labor force. The second factor deals with the number of veterans who are participating in the state's employment service delivery system. To meet this requirement, a contractor must determine the number of veterans within the previous 4 quarters participating in the employment service delivery system. The third factor requires the contractor to determine, based off their records, the applicant ratio and hiring ratio from previous years. You can obtain the data from the Ofccp website. The fourth factor, the more subjective portion, is to determine how effective your company's outreach program is. The fifth and final factor allows for a contractor to take into account the local conditions in terms of veteran employment. Any other factor that may affect a contractor's ability to hire veterans can be addressed in this fifth requirement. Finally, the affirmative action plan must cite the Equal Opportunity Clause. It must include this specific language. This contractor and subcontractor shall abide by the requirements of 41 CFR 60-300.5a. This regulation prohibits discrimination against qualified protected veterans and requires affirmative action by covered prime contractors and subcontractors to employ and advance in employment qualified protected veterans. The simplest way to comply is to obtain an EEO is the law poster. It is also the responsibility of the prime contractor to ensure that subcontractors are in compliance with the citation and presentation of the Equal Opportunity Clause. There are some areas where you are required to post job opportunities. Contractors are required to post job opportunities with state workforce agencies. Contractors also have to provide job postings in a format that can be placed on the Employment Service Delivery System. This allows postings to be included in state's one-stop delivery system. One-stop delivery systems were established under Section 134 of the Workplace Investment Act of 1998. Each state is responsible for developing their own effective format by which they can present job opportunities to veterans. Contractors are also allowed to use third-party vendors to place postings in the State Employment Service Delivery System. Let's go over the Affirmative Action Plan posting requirements. As we discussed earlier, contractors with collective bargaining agreements must notify union representatives and request cooperation of the affirmative action policy. They are also required to include in their employee handbooks, or in one way or another, make it available to their employees. For contractors who have employees who work remotely, electronic notices are allowed. There are a few things to keep in mind, however. Contractors are required to have actual knowledge that the employee received a notice. This can come as a certified receipt from the employee, or just an email stating that they have received it. Or you can provide an employee with a computer they can use to access the posting. And of course, as we discussed earlier, contractors are required to post the affirmative action policy in each of their establishments.
If you have any questions or need assistance, go to the PsychArmor website or call the PsychArmor support line at 844-779-2427. Thank you for completing this course and taking that one step further in learning about our American veterans.